the court at the 4th District was reaching a conclusion about the effects of Ms. Goga's dishonesty on the entirety of the proceedings, and somehow reaching a conclusion that the trial court never reached. There was never in the record any finding by the trial court about how her dishonesty could be cabined in any way, shape, or form.
Well, in fact, there was a finding directly to the contrary.
Yes.
Because the trial court found, based on the totality of the circumstances and evidence before this court.
In this Florida Supreme Court case, the justices are dealing with a pretty straightforward question. If someone lies in a lawsuit and the trial judge finds a pattern of dishonesty, should any part of the case still survive? The case involves Publix slip and fall claim. A plaintiff, the trial court says, repeatedly lied about her injuries, but the appeals court brought part of the case back. Now, the Florida Supreme Court is trying to figure out whether that makes any sense.
It has been established by clear and convincing evidence that the plaintiff's lies and deceit permeate the entire case, and that she has intentionally and repeatedly misrepresented herself as overly impaired in an effort to perpetuate a fraud on this court. So there was a specific finding that it permeated the entire case.
Absolutely, Your Honor. Absolutely. You anticipated my next thought.
Do you agree, though, that for us to, you wouldn't know from the four corners of the opinion that liability was still contested?
You are correct. There's nothing in the four corners, but
so where does that leave us on jurisdiction? Because if I read the opinion before I knew what was going on, obviously now we have the whole case and we understand that liability was contested and everything. But if I'm going through the exercise at the jurisdictional stage of just reading this opinion, and I see the reliance on the 50 CA case, Jimenez, I guess. And I see the description of that case where liability was not contested and it wasn't contested that they had, medical costs and whatever. And then I see a case that says, applying the reasoning of Jimenez, we say she can't claim this, but she can claim that. I mean, wouldn't the most natural reading of this be, and it seems like this was a mistake, but if I'm just focusing on the four corners, wouldn't the most natural reading of this opinion be that those things weren't contested in this case either?
I think you can't. Well, no, I don't think we can draw one. We can't draw a conclusion one way or the other. I will concede that point to Your Honor. But our contention isn't that conflict arises because of what Jimenez holds. We contend that conflict arises, and this is the second prong of Cartonis, which is where you have identical facts or substantially identical facts, and you have diametrically opposed conclusions as to the outcome.
But isn't the liability being contested? Isn't that the identity of facts that you're relying on?
But I'm not comparing Jimenez with Goga. I am comparing Jimenez with Willie Coons. And now we have the benefit of also the 5th District's decision in Epps. In both of those cases, in fact, the exact same argument was raised by the plaintiff, relying on Jimenez, ironically enough. They both said, you shouldn't dismiss, make it a narrow remedy. And both the 3rd in Willie Coons and the 5th in Epps said, no, we're not going to disturb the trial court's jurisdiction, the exercise of discretion, because there's plenty of evidence to support what the trial court did, and we're not going to parachute in and change it.
But even in your briefing, you say that in a case where liability isn't contested, that it could potentially be an abuse of justice. And so I don't want to. I mean, I understand that there may be a benefit to this. Seems like just a bad. I don't know what the court was thinking, but if I'm just reading what's here. And if part of the jurisdictional thing and also the precedent, if I were reading this case going forward, I would read this case as standing for the precedent that when liability isn't contested, and again, four corners, because I need to know a lot more from outside the opinion to know why this is as bad as it is, right? If I read just the four corners, I would think, well, we have a case where, based on the way they're using Jimenez and describing it here, liability isn't contested. The fact that she had medical treatment wasn't contested. So you slice off the stuff where the lying is relevant, and for the stuff where it's not contested, you move forward with that. I mean, that seems to me that that's what this case stands for. And for us to kind of do what you want us to do, we have to kind of recharacterize the opinion in a way that's to make it say more than it does.
I think if you look back at, well, I understand the point Your Honor is making, and I think where the court should be exercising its jurisdiction is to reconcile the outcome here, which I think Your Honor has already acknowledged is difficult to understand, with the correct outcomes that happened in Willie Coons and in Epps, based on the same facts. All right. And that's where I think
let's take Epps off the table because, it is subsequent in time. It sounds like what you're really arguing is that we need to answer this question jurisdictionally. Is a matter like this where liability, say, we can't decide on the basis of the four corners of the opinion what the status of liability is in terms of its degree of contestedness. Is it going to come out differently in the third than in the fourth? That is one way for me to sort of articulate the jurisdictional question. It sounds a little bit like you aren't able to give a conclusive answer to that to the chief. I want you, perhaps let's take another shot at it. Is that your argument, that if this case were presented in the third, we would expect it to come out differently than in the fourth?
Absolutely, yeah.
Okay.
Absolutely.
And what about the chief's point about how you might, distinguish on the basis of the absence of a liability finding in the four corners of the opinion? Because I would bet that's what you would argue to distinguish it, right? If you had the same case in the third.
I would. It is in fact what has been argued. So I'll concede that point that it's not there. But we do have these, and I don't want to go out. I want to be careful about going outside the record here and what I know is happening with this decision already.
Right.
So, I apologize, Your Honor. I'm not sure that I can directly answer your question, except to say that I think it is as fair a conclusion if you look at how Goga, or how the Fourth District describes the case in Goga leading up to where it cites Jimenez, that it is differentiating. The only thing it picks out as being uncontested is this question of supposedly the objective medical damages. It seems odd for the Fourth to have picked that issue as being not subject to her testimony because it can somehow be objectively verified, and have ignored or have not discussed, for example, how those damages could have been caused by Publix in the first instance.
That sounds to me more like it sounds like a more complete answer than what you said about it not being in the four corners. You're kind of saying it is in the four corners, but I'm looking at it's like a figure in a painting that casts a shadow, and you're saying that figure is in there because I see the shadow or something like that.
I am drawing my own. The chief drew inferences about how you read Goga as it's written because they cite to him, and as therefore they must have.
And they don't just cite it; they say, I think they
talk about the facts.
Boilerplate about the standards, which you say basically there isn't. Because I'm just trying to figure out what we're doing here, right? Mm-hmm. Error correction versus truly clarifying rule of law, whatever. And so all of this is boilerplate. You say that the DCAs are all in agreement basically about the standards. And then we get to finally the last 3 or 4 paragraphs where they're doing all the work, and they conclude by saying adopting the 5th District's reasoning, comma, blah, blah, blah. And so I then go back to how they described it, and they talk about the reasoning being where when this isn't contested and, we carve out the contested part and we leave the uncontested part. So, I mean, I understand. I mean, it may be that the world is a better place if we quash this because it just doesn't seem like it's a good opinion it seems like it ignored sort of what was going on. But if we're being, sticklers about jurisdiction and what we're really doing here, it seems like we're going to have to like kind of reshape what the opinion says to get there.
Well, I'm sorry, Your Honor. Go ahead.
Could I ask a question that I think it takes a little different tack than the way you've analyzed it? But what I'd like to focus on is the discrepancy between what the two opinions say about balancing the policy favoring adjudication on the merits and the importance of maintaining judicial integrity, or the integrity of the judicial system. Now, that seems to be the kind of the reasoning process that is driving the decision in Goga, this balancing. Now, I don't see that in Wiley Coons, and that's actually, I mean, they didn't see it either. I mean, in Goga, I mean, they kind of say, well, they don't talk about that. But, and I understand you don't rely on that as a basis for the conflict, but it seems like to me, when you look at the two opinions, the way they're analyzing it is kind of fundamentally different, because one talks about that and the other does not. One just kind of, they talk about other things related, but that when it comes down to that balancing, which basically is the principle on which they are deciding, the Goga is deciding it, that's absent from the other case. Why isn't that in itself a conflict?
It is a conflict, and it certainly, and it is, I know, again, Epps comes after the fact, but Epps squarely addresses the balancing of the two policies.
Well, I'm kind of still on the jurisdiction question.
Right, but I think that creates conflict, how the 5th District applies that balancing and how the 4th DCA in Goga applied the balancing are diametrically opposed to each other.
Well, but I think it sounded like what the question was going to was whether the balancing has to happen, and then there's the application. So if you go back to the First Circuit case, which seems to be the fountainhead of this whole thing, and they make the distinction when they're talking about abuse of discretion review, they're making the distinction between, one way for a court to abuse its discretion is to kind of balance the wrong things, or not to put things in the balance, that to not consider factors that would be relevant. And then the next layer of potential abuse of discretion is when you agree, the appellate court agrees that the court considered the right things, but then applied them in a way that abuses discretion. And so I guess one question could be, is there a conflict with this case and some other DCA case at the level of what are the relevant considerations, or does there have to be a balancing at all? And then you get down to the next layer of, okay, assuming that we have to balance, and assuming that we agree what the relevant criteria are, or considerations, then did we apply it in a wrong way? And it seems like if we get to that level, then there has to be a difference in the facts for there to be a conflict, because you'd have to be agreeing on the test, agreeing on the need for balancing, and then just getting diametrically opposed results in the application.
But look, could I ask this? I think it's a follow-up to what the Chief is saying. In Wiley Coons, is that the way you say it?
I've always said Wiley Coons, but it could be.
I'll say in the 3rd DCA case, that's the conflict case, the asserted conflict case. Is there really anything about balancing?
No, they do not engage in that analysis.
Okay, so one court is saying you've got to do this balancing, and the other court is just ignoring it. So that seems to me to be a basis for saying that there's a conflict.
But then the irony would be that we would agree with the 4th that you have to do balancing.
Well, we may or may not.
We'll see.
I mean,
we'll see.
Counsel, would you think?
Just redo the whole test.
Would you think that perhaps, the test is a federal standard, right? It's never really been adopted or mentioned by this court, to my knowledge, the balancing. In fraud case, never here. I think it came from a federal case in the maybe 80s, 90s.
Yeah.
Would you say that perhaps a difference here is that whatever the standard of review is that the DCAs have created, which appears to not exist in any other area of law? I mean, I think in this case, they said they applied the abuse of discretion to the legal conclusion. I mean, I don't know any other place we do that. That's not really, we have abuse of discretion for matters of discretion, and we have de novo for legal conclusions, and we have competent substantial evidence for facts. It's not, this is a very unique standard. Do you think that the problem is, that none of the DCAs really agree on what that actually looks like? Problem A. And the second part is that, particularly between Goga and Willie Kuntz, they focused on this sort of stringent review on both whether fraud existed and the sanction in Goga. So they're reweighing, as you said, they're applying this very strict standard. They're applying this balancing test to the sanction. None of the cases from the third seem to do that. They apply that strict standard to the question of if fraud exists, but once they determine fraud, it's just kind of a standard. Would a reasonable judge, using the discretion, find the sanction appropriate? And if so, it's affirmed. They don't really have a heavy analysis on that part. They don't do the balancing test. They don't do any of that. Do you think perhaps that is one of the bigger distinctions in the two?
I think that's a fair assessment, Just.
At the core of this case is a bigger issue that the court keeps coming back to. If the legal system finds that somebody has been dishonest throughout a case, where do you draw the line? Do you throw everything out, or do you try to separate what might still be legitimate? That's what the Florida Supreme Court is being asked to decide here. If you like what you heard, click the like and subscribe button.